Hi, I'm Debbie Moraes. Once again, welcome to Legal Matters, the program that's been designed to address the critical, sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. Today, two critical issues about same-sex marriage. It's now facing the Supreme Court, so it affects you, me, and just about everyone in some way. The Federal Defense of Marriage Act, also known as DOMA, and Proposition 8 just became complicated, came from California. Those issues today we're going to discuss. What exactly are those issues? More importantly, what do they mean to you? The arguments for and against, what is the impact? That's what we'll deal with in this segment today. And as usual, we will welcome from Bazar, Grasso Law Firm in East Providence. To my left, Jackie Grasso, and to her left, David Bazar. So let's set it up. Let's tackle what is DOMA? Define it from the legal standpoint.
Defense of Marriage Act was a law that was passed by the United States Congress in September 1996. It was signed into law by President Clinton. Basically what it did is it codified the non-recognition of same-sex marriage, and it gave the states the right to do the same. So for purposes of federal benefits, the federal government doesn't recognize a same-sex marriage. They recognize a marriage between a man and a woman. So if somebody wanted to apply for federal benefits, Social Security, filed a bankruptcy, for instance, if you were a same-sex couple, you were denied that right. And the states were able to do the same, and consequently some of the states enacted what are called mini-DOMAs and did the same thing. So frankly, people of same-sex relationships were denied federal benefits.
And so let's start out of the gate that flies in the face of what people who think that federal government should be limited in size and scope is stepping into an area that traditionally was relegated to the states. States define marriage, states define the laws for divorce within their boundaries, and for the federal government to step into this area in the first place, many people thought was an overstepping of what their rules and regulations should be as far as areas that they should legislate.
So, of course, to be clear, federal was the DOMA situation. And then other states have started to say, well, we'll legalize it. I think there are 12 states now. Others, I'm sure, are thinking about it. So when they're talking about possibly reversing it, is it really constitutional? Didn't one state have the ability to say, even though it was legal in Vermont, at one time it wasn't legal in Rhode Island. So if you got married in Vermont, you moved to Rhode Island, you're out of luck.
Well, there was a case that went to the Rhode Island Supreme Court, that same scenario, except the couple with two women, Chambers versus Armstead, I believe. Two women got married in Massachusetts at a time, as you know, in Massachusetts now legalized same-sex marriage. They later moved to Rhode Island, satisfied the domicile requirements, lived here for 1 year, which our divorce statute says that's what you need to file for divorce. They filed for divorce in Rhode Island, and to make a very long story short, they were denied the rights to receive a divorce because they said, Rhode Island said that our state statute defines marriage between a man and a woman.
Which was a very unfortunate decision.
Yeah,
because the divorce statute says that if you're married, you can be divorced. And the only thing you need to meet as a requirement is that you're a resident or domiciled inhabitant of the state of Rhode Island for 1 year, as Jackie said. So if you got married in Nevada, for example, and let's just say Nevada had a rule that in order to get married in Nevada, you had to be living there for 1 hour. But let's say Rhode Island had a rule.
It's actually 6 weeks.
But just for the sake of argument, Rhode Island's rule is you have to, and it doesn't exist, but let's say it said in order to be a valid marriage in Rhode Island, you have to live here for 1 year. So under that reasoning of that case, it would say, well, that's not a valid marriage in Rhode Island, even though it's a valid marriage where it happened, so we're not going to recognize it. The divorce laws, the rules for requirements to be able to get divorced in Rhode Island just has to give full faith and credit to the state where the marriage happened. So if in Massachusetts it's a valid marriage between two men or two women in that case, then Rhode Island should have recognized the marriage and had the jurisdiction to grant the divorce. And there's a good dissent that talks about that.
Well, and the hardship that caused was between the couple, because essentially one of party in that divorce had to move back to Massachusetts, live there for the requisite amount of time, which was 1 year, and then file for divorce in Massachusetts. So it caused a hardship on them because your life is here in Rhode Island. I'm assuming that I think they owned a house together. And it really wasn't fair because under the full faith and credit clause, if I was married to David in Massachusetts, we moved to Rhode Island, we're here for 1 year, we can legally get divorced because they've recognized that marriage.
Right.
But they wouldn't recognize the Massachusetts marriage.
Well, it makes sense that you'd respect the jurisdictions.
Exactly.
But the fact that they didn't, of course, that's one issue, and you would think that by now, here it is 2013, and we understand that the Supreme Court is supposed to be making some decision. We're not sure what that's going to be in the month of June. At this day and age, you'd think many people would just forget about it, accept it, but the socioeconomic, the impact for workers, this has become very complicated, and I guess even actuarials are starting to recalculate what they're going to be doing for benefits. So it's going to be in the Supreme Court's lap. What do you see as the possible options? What do you think might be the possible options?
Well, one of them would be they just outright deny. They dismiss the case. Another one would be that they rule that the Defense of Marriage Act is unconstitutional, which basically would say that the states do have a right to legislate the definition of marriage. Or they might rule in their favor. So there's one of three possibilities there.
And it seems that it differs in its range. One's very broad, sweeping, and will encompass all. But I've read that there's something about whether or not those who raise the issue in the first place have what they call standing ground. Do they have a legitimate right to bring the case before the Supreme Court? Could that be an issue even in of itself, that it's not right for any single state to raise the issue, whether it's about DOMA or the other one we're going to talk about, Prop 8?
Well, standing is a person's right to bring a case. So to make it in simple terms, in a personal injury case, if I'm in a car and I'm in an accident and I get hurt, I have standing to bring that case. If my wife wasn't in the car and wasn't hurt, she doesn't have standing to bring a case on my behalf. So it's the right to bring the case in the first instance. The issue in some of these cases is who's affected and how are they affected, and are the people that are bringing the case those people who are affected by the case. Standing is often an easy way for a court just to get rid of a case that it doesn't want to decide for whatever reason, political or otherwise. So if they can get out of a case by saying, wait, you folks didn't have standing to bring it in the first place, then it's as if they never weighed in on the issue at all.
And not to be political here, but in the situation where Obama, in a rare situation, chose to refuse to defend
He declared it unconstitutional.
Right, so now it leaves, hate to be political, but it left the GOP party, the other party, if you will, in the position to do the appeal to the high court. And so doesn't that, well, never mind, it makes it a political football, but is that a reason in and of itself to say they don't have standing ground because it was party activated?
Well, Obama basically announced that he thought the DOMA statute was unconstitutional. They wouldn't object to any lawsuits, but they didn't outright try and change the law. It was more of an opinion than anything. It wasn't codified. I don't know that they attempted to pass the law, but it would no longer defend the federal government's position on Defense of Marriage Act. That's what the Obama
So what Obama
administration
did was directed the Department of Justice to no longer defend the act in court. So as you said, the GOP directed the bipartisan litigation, whatever, BLAG, I think is the acronym. But the interesting thing is, it goes back to what I said at the beginning. The GOP directed them to defend these suits. And if the DOJ, the Department of Justice, isn't jumping in, perhaps they do have standing. But the GOP is the party that's supposed to stand for the view that the federal government should be limited in people's lives and we should have less government in our lives. And DOMA is putting the federal government directly in people's lives, and it is a thing that belongs in the state. And politically, just to go there for 1 minute, the issue is there enough political support in the House and Senate to repeal this? I think you could probably get it out of the committee and to the Senate floor, but I think it needs 60 votes to get to a full Senate vote or a House vote, or whatever the majority requirement is. And I don't think that they have enough political background or backbone to get that put through.
So if they're really talking about one aspect about DOMA in particular, the benefits, which is attached to money, never mind religious, political, etc. When they're talking about a benefits provision, that certainly is going to be causing more to hop on the bandwagon because benefits equals money.
Well, yeah, certainly if you're denied federal benefits because you're a same-sex couple, that means you could be denied Social Security survivor benefits. You may not have the tax advantages for estate tax purposes when a spouse dies, so that creates a financial hardship on the surviving spouse. It could have ramifications for immigration purposes as well.
So-
Yet another political hot
So
potato.
the justification in some quarters is that there's a financial impact on federal government and money if people of same sex can be married and get the same benefits that everybody else gets. The other side of that coin is there's a Fifth Amendment impact on equal protection, which is being affected by saying you can't have the same benefits.
Well, we'll talk about that in a second, but let's just continue on the marriage situation for a second. If you think about some byproducts of marriages, there happens to be children involved. Well, we understand that in the current law, stepchildren are dependents, one parent, one step-parent. That's pretty clear who gets covered and what. What happens now with DOMA, and if it's upended, what happens to the child right now who might not be able to receive benefits? It'll change how they calculate welfare. And what happens to children as a result of all of this? And does that weigh in on the Supreme Court's collective minds?
Well, when all of this started, one of the things lawyers were telling same-sex couples was if you do decide to have a child, whether it be if it's two women and one is impregnated by insemination, they're recommending that there be an adoption of the child. So that pretty much solves that problem. Because if it's a legal adoption, you're a legal parent. And it creates a problem if the other party doesn't adopt the child and then the relationship breaks up. Because now what rights do you have to the child as not being a biological child?
So how would you protect those rights?
Yeah.
Perhaps
Other than
through a
de facto
contract?
parenting.
Well, you could file for a de facto parenthood, like under the Patinato case in Rhode Island. Perhaps, and I don't know if it would be considered enforceable or not, you could enter into a contract that says, I'm going to pay X numbers of dollars for support, and I'm going to have visitation. And if there were a contract, where would you enforce it? Superior Court?
Yeah, yeah.
And might this all just get kicked back to the lower courts or the state courts if they choose to, I don't know, dismiss it entirely?
Oh,
Would it
they
come back?
definitely would, yeah. But now we have a lot of states that are recognizing same-sex marriage,
Right.
Rhode
Yes.
Island being the most recent.
And some of the cases that are pending have been decided in lower courts already, so if the Supreme Court throws it out, theoretically what happens is whatever the lower court decision is upheld.
And you started to approach the subject of just equal protection. So that's more about what Proposition 8, while it's a California issue, it really isn't a California issue. So California, you can give the rest of the story if I can distill it a bit. California did pass same-sex marriage. Then they had a vote, and 52% or something like that said, we're going to ban it, and so they put a hold on it. Now it comes up and rears its head again, where the opposition and supporters are quarreling over it actually denying equal protection under the law if you are not able to be married and take full advantage of, never mind benefits, but just civil rights, equal protection under the law means what? Not just marriage, but what else does it imply?
Simply, it's your right to receive a benefit or a privilege that anybody else would.
Right.
That's what equal protection is.
So
through
the right to be
Amendment.
married, the
Should
right of
apply.
association is impacted. As we said before, there are many benefits that are impacted. The right to inherit from your spouse, tax-free, without an estate tax issue, is impacted. There are a million, probably, rights that are impacted.
And will that differ whether they refer to it as a civil union versus marriage? If it's civil union that they'll acknowledge and give pension benefits to or health benefits to, does that get murky about equal protection?
Yes, it does.
It does.
Because with a
Found on
civil
it?
union, you're still not recognizing it's still not a legalized marriage.
Right.
It's just simply saying, oh, okay, you can have a civil union, but it's one step short of saying you can be married.
I would equate it back to the separate but equal argument
Yeah.
that was overruled, as saying you can't have that as a standard. You're close, but you can't be exactly the same. So that's not acceptable under the Constitution. You're entitled to the same equal protection under Amendment 5, then you're entitled to all the rights under it, which you are. And the other part of it is also the DOMA Acts impact these rights too. So they're being challenged under the same constitutional issues.
And with those who are saying that they want to upend this, we're talking about Supreme Court's decision, but what happens if they actually want to have the opponents, for example, if they want to even push the expansion of DOMA, the defense of marriage, which will make it even more difficult? Could the Supreme Court be involved in that? And I guess the answer might be yes, because if it's unconstitutional, it will
Well, they would
change.
have to litigate it in state or federal court and would have to be appealed through the circuit.
Will it
of
go
the-
back to California then?
Proposition 8?
Yes.
It wouldn't, well, they would have to relitigate the issue.
If the court doesn't address it.
Correct. It would have to be relitigated and go through the appeals process at some point, file for writ of certiorari with the Supreme Court. Then they decide whether or not they want to hear the case.
If you were betting people, and I know you're not, what would you bet on relative to Proposition 8 as it talks about civil or equal protection under the law? Is that a wider net that they would cast?
So in order to really handicap that case, you would have to go justice by justice and try to figure out which justice would be on which side of the issue and who are the swing justices on that and what they might do. And I'm not going to do that.
You're not going to try to second guess. They're hard to second guess.
This
as a
issue
body anyway.
is as controversial as Roe versus Wade. I would say that's how controversial it is right now.
Do you think that there's a chance that they would just, on both cases, as we said, dismiss and choose to not choose?
Well, they can do that, and there's a number of little outs that they can take to do that. But if they granted the writ of certiorari in the first place, if they can get a meaningful majority, 5-4, to make the decision, then I think they'll make it. So I'll handicap that. I think they'll give a decision on the merits.
On both
Yes.
Prop 8 and DOMA.
Yes.
Okay, what happens to the immigration issue? I mean, not, again, to be political, but many have said we've moved so much farther forward than we ever have with that Gang of 8 who have cobbled together an immigration plan. Well, suddenly, never mind your Social Security and pension benefits, suddenly that's going to impact on who gets a green card, I guess. Care to comment about that?
I'll leave that to you, Jackie.
That's more political, that's as political as your other question.
But it will affect someone getting a green card.
It will definitely, and now you're going to have immigration cases being litigated in the same way that the equal protection cases are, with Proposition 8 and with rights to federal benefits on
Let's
the
go back
Windsor
one
case.
step. Talk about bankruptcy, for example. And
Well, at one time, bankruptcy is a federal, United States Bankruptcy Code it's a federal law, okay? So because of the Defense of Marriage Act, the federal government says marriage is is a union between man and woman. Two people want to file bankruptcy that were married in the state of Massachusetts. As you know, Massachusetts recognizes same-sex marriage. They want to file in Massachusetts bankruptcy court. What was happening was that you couldn't file a bankruptcy because it's federal law, and they don't apply the state law when you file a federal bankruptcy. Several years ago, that was changed, and it was changed to allow same-sex couples file a joint bankruptcy. Prior to that, they had to file two separate bankruptcies.
so there was a challenge, and actually, if my recollection is right, the petitioners who wanted to file the joint petition lost. But the bankruptcy court agreed not to enforce the DOMA anymore and allow them to file
challenging it
jointly,
anymore.
so they won't challenge it. So my point is the same thing could happen with immigration, that the Customs and Border Patrol, whatever it's called these days, may choose not to enforce DOMA when people apply. So what happens is a spouse can petition for a spouse for a green card, for citizenship, whatever. And now if you have a same-sex marriage, that spouse under DOMA might not be allowed to petition in the
Because
federal court
you're not legally a spouse.
by under the terms of DOMA. But if the court or the agency applies it the same way the bankruptcy court does, they may not apply that as a defense and allow you to do it eventually.
You know, the bird's eye view of this, or looking at the amount of people and dollars that are impacted here, apart from the fact that you just talked about bankruptcy, you'd have two sets of bankruptcy, two sets of lawyers, two sets
legal
of
fees.
legal fees,
Two
sets
filing
of
fees.
Two filing
fees,
yeah.
two sets of courts involved. Then you'd have more people involved with Border Patrol, more people who are going to be on board politically with this, political action, PAC campaigns getting. It seems to me that apart from what your own personal or religious or socioeconomic ideas might be in the first place, by the time you sit down and start calculating this, more and more dollars are being assigned to it the longer this clicks on, and it seems that maybe even if I weren't a betting person, maybe there's a reason for the Supreme Court to put an end to this, just so that these swirling waters will calm. Mm-hmm. What about from an employer's standpoint right now? Clearly, there are some issues that are going to change on health benefits. We have Obamacare; it's supposed to help everyone to have health care. Well, if you have to work so many hours, 40, 30 hours, or whatever it is, now suddenly, depending on how the Supreme Court decides this, might this even push more employers to get under the radar so that they have fewer people working 30 hours if you're not legal, so we don't have to pay
Health benefits. You're going to see a ripple effect.
This sounds like a tidal wave. I don't know if I imagine this as ripple, but does this not sound like employers are going to need to get on this bandwagon quickly and start having more people in HR starting to calculate this based on the Supreme Court's decision?
Some employers are covering health benefits for same-sex couples. In
Right.
Rhode Island, the state covers it as well. You don't even have to legally be married in Rhode Island as long as you can show a common law marriage between two people. But some employers are covering health benefits. Those that don't, you're exactly right. There's going to be a ripple effect, and
I might argue that
economically it would be.
the economic impact of not having someone covered under medical insurance might be a bigger impact than requiring an employer to contribute at least to the coverage for a spouse of a same-sex marriage couple.
Good point. Of course, as everyone is scrambling to assign some sort of numbers to it, apparently the IRS thinks that it will increase the amount on the tax return. Who's going to be interested in the marriage penalty tax after all this gets settled out? And somewhere a number of $5,800 in the coffers of the IRS will make a difference by the time this gets settled out if they reverse DOMA. This is really very interesting that so many people are trying to assign a number to it already. In your offices or in other lawyers' offices, do you find that many people are coming to you and asking about what they should do? Should they wait before they think about going to another state? I mean, Rhode Island has it settled right now, but are you more likely to hear that people are interested in waiting to see what happens before they do estate planning and all the other things that affect married couples and money?
Well, we haven't come across that situation, but certainly those other attorneys that specialize in estate planning, I would imagine.
Yeah, this is
that's
my
what they're
take
telling
in
you.
Rhode Island. I believe it takes effect August 1st. So if I were a person who was going to marry another fellow on August 1st or thereafter, I
You'd
would
wait.
go to a lawyer and treat it after that point in time just like, and I, as a lawyer, would treat that couple just like any other married couple and do my estate plan accordingly, because as far as I'm concerned, if you're legally married in Rhode Island, then you're entitled to follow all of the rules and benefits and detriments of being married. And so I would absolutely do estate planning as they were a couple at that point in time, and I think it's much more reasonable to try to figure out how to do that with a marriage than under this old civil union law that we had. So I would move forward with it after August 1st, if that's the date that it takes effect, as I believe it is.
In the short amount of time that we have left, I guess one other question that comes up, if all of this is considered constitutional by the Supreme Court, is there any room for states' rights to raise their own issues again, for or against anything relative to gay marriage or civil unions? If it's considered
It's usually-
unconstitutional, does that put an end to all things, or do we end up having loopholes by the state who gets creative? Is there room? Is there wiggle room?
So you're saying if the Supreme Court says DOMA is constitutional, and states have passed marriage acts, marriage equality acts, are those acts at risk because DOMA is constitutional? And the answer is no.
No, okay.
But the federal benefits that DOMA is taking away from a married couple may be at risk.
So does that impact even on their tax return? Federal says, no, you can't. State of Rhode Island says, yes, you
Well,
can.
you wouldn't be able to file a joint federal tax
Right.
You can't
return.
do- That's right,
Perhaps,
perhaps.
Perhaps.
right.
Yeah.
Because I
They don't
believe
recognize the marriage.
that if you
Federal government.
file it and then it gets challenged, the Obama administration at least might not try to enforce that, although they have issues with the IRS already.
Right, yeah.
Other issues.
Other issues, my goodness. What other issues do we need to talk about? What's the 14th Amendment?
So,
Equal protection.
yeah.
It is.
So the 14th Amendment followed the Civil War, and it was taking the Fifth Amendment, which is the equal protection, and at least in this context, the Equal Protection Act of the Fifth Amendment, and making it applicable to all the states.
Okay.
After the Civil War, to enforce, the freeing of the slaves and all of the other rights that accrued. States were not subject to the Fifth Amendment. It applies to the federal government. This applies to states.
Now it makes sense why they would have that issue raised in particular.
Right.
Apart from California, have you heard of other states getting involved with courts cases that they want to take to state Supreme Courts, never mind U.S.?
Not to my knowledge.
No, it's really about California that's
Yeah.
leading the bandwagon
Well,
for the
I
I think
Fox
everybody's
US.
waiting to see the outcome.
It's because of the context of what happened there. They had a law, then they went to the
Statewide
vote,
vote.
which you don't vote on civil rights. That's not how you pass civil rights. Either you have the right or you don't under the Constitution. That's decided by a court, not by a vote of the people.
Well, they tried to do that in Rhode Island, put it
Yeah,
out to
that
the
was
vote.
talked
Yeah,
about.
Yeah. and-
But it's just not the way you determine whether or not somebody has a civil right.
At the moment, as it stands, since they haven't made a decision, the Supreme Court, someone who needs a working visa, they're not documented, what's the process right now for them, considering the Supreme Court has not made a decision?
I think everything's on hold.
Yeah, I would have to
I wouldn't
ask
even
an
apply.
immigration expert on that, but I would assume that if they're going to apply DOMA until otherwise instructed, that you can't have a spouse who's a same-sex spouse apply for you.
It sounds like we have, between immigration, even actually, we were just reading about mental health, too, that apparently this has caused enough stress that it's prompted even more health care costs.
There are a lot of unintended consequences and costs that if you're going to go out and try to calculate out, and I'm not going to sit here and even guess at all of the expenses, plus and minus, that this would have, the unintended consequences are even more difficult to calculate.
All of this certainly has brought up so many issues. I remember initially people were talking about it'll help the economy when we have same-sex marriages because we'll have people doing better,
Booking.
more elaborate
Yeah,
weddings.
and booking parties and weddings.
Well, we say stay tuned. Our discussion of legal matters will continue. We'd like to thank Jackie and David once again for joining us.
Thank you.